course coordinator for this 3-day training program. We are into the inaugural function of 3-day short-time course of
an expert in criminal law whose insights will no doubt enrich our understanding of these transformative legal changes. I also extend a respectful welcome to our director, Sri B. Pradeep, whose leadership continues to steer this, especially the prison and correctional officers. This is not just a training program, it is a shared journey of understanding, adaptation and reform. We believe that by the end of these 3 days, each one of you will carry valuable insights, practical tools, and confidence to implement the new criminal codes with clarity and purpose. Once again, I welcome you all and wish the program meaningful deliberations and impactful outcomes. Thank you.
By the introduction of new criminal laws, that is BNS, Bharatiya Nyaya Samhita, Bharatiya.
This act dismantled.
Any special law based on that only. There are number of laws enacted in favoring the children and women. For I'm present here. And it is a great privilege for me to be here in front of you. And my heartfelt thanks first to the person who is invited me here, Ansar sir and Madhav sir, and first of all the director of this academy. So it is a great opportunity when we are invited as a chief guest or the resource person. When we are participating for the audience, maybe always the students or the minimum level of officers. So this is the first time I am appearing before you, like you are almost equal to me. Or sometimes about to me also. So it is a great privilege and very honor for me to be here as a chief guest for the gathering. Again, my heartfelt thanks to the academy as well as the director and the professors and those who are participating in this program. Thanks a lot again. So this is the training program for 3 days is regarding new criminal laws. So this is came into force from, as it is director narrated the key points for all these new criminal laws. Already we discussed what are the new changes and is it a welcoming change or in Tamil we have to say Matram Ondre Maradadu. So the change is inevitable. That is required also when in the parliament when we are framing the constitution, there is an amending provisions called Article 368 that everyone knows. So, so you can't think like that. I'm coming from the law basis. That's why I'm talking about constitutional law and the parliamentary process. This is very essential that every citizen should know that fundamental law, that is constitutional provisions. When we are when the drafting committee framed Article 360, that is amending provisions of the Constitution. So there are a lot of agitation is there. Agitation means. The constitution is a very lengthiest one. We are taking it from other sources, which one is best and framed like that. But the Article 368, if the majority of the Parliament is giving consent, even the total constitution can also be amended, also be changed. So that time there is an opposition from the Parliament that it should be very rigid. But the drafting committee as well as that time Prime Minister Nehru suggested that change is necessary. As per the requirement of the society, public, it should be changed, otherwise the purpose of the law itself is failed. So the change is very essential. But we have to analyze whether this change is required at the time, need of the hour, or is it a burden for the society. That is the only thing we have to analyze. So in new criminal laws, is it a requirement? There are a lot of agitations, protests, and we saw the medias that everything is flashed. Majority of the advocates are agitating against this criminal laws and the parliamentarian. The one comment is very genuine and requirement is when the law is enacted, a lot of sessions will be go on for debating. That is very, very essential, whether what are the positive things are in the new laws, what are the negative things which can be amended, which cannot be, what are the lacunas, everything we used to discuss in the parliament, that means MPs. But in criminal law, when they are enacted, only 5 hours of argument happens. Immediately they came into force. So the only reason what the government is, the parliament is saying that colonial law enacted from 1860 to 1872. So after this much of years, nearing about 165 years, we need changes. We can say that the imprisonment may be genuine or reasonable, but the penalties are very minimum when we are comparing with the value of the things when it is enacted by the Macaulay in 1860 IPC. Now the 5,000 rupees, 2,000 rupees, 10,000 rupees is nothing to pay the penalty. The criminals are simply they are paying and coming out. So this has to be changed. That is the main thing. Otherwise, imprisonment basis it is okay. When putting in the jail for 2 years in 1860 and in 2025, both are similar. But the value of the penalty is totally irrelevant to the value of the rupees. So that requirement is like that. The need of the hour is to change as per the requirement of the hour. What are the requirements now? So that's why these are the laws. In the advocate's perspective, whether the change is comfort for them or not. That's why they are agitating. For example, if it is filed, any criminal cases, before 1st July 2024, then they have to follow the old existing laws. But if it is filed 1st July 2024, they have to follow the new laws. So, and advocate perspective, they have to be very thorough in existing laws as well as the new laws. That is the thing they have to, it is only criminal laws always to be retrospective. It cannot be a retrospective effect, it is only a prospective effect. So that is the main problem they are facing, that's why they are agitating. The welcoming futures of criminal laws is, as I said, in petty cases, they converted into communal service. Whether is it available in the existing laws means definitely not in the law. But when you are seeing a Tamil movie called Kadaikutti Singam in one film, the court, lower court, district court, for giving penalty, do remove the unwanted trees in the lake. Whether it is justifiable, whether it is as per the law. We can ask this question. It is a discretionary power of the judge. It is already available, but it is enacted in the names, explicitly in the law. So that is the one welcoming future. And speedy trial. So the case should be disposed as early as possible, because if the FIR filed, the charge it may not be filed for a lengthy period. The victim becomes so tired to go to the police station and the home here and the roaming. So certain stage, after a certain stage, they will be very tired and they will leave it as it is. Judgment, I don't want to justice, leave it. Is it more than enough for me? So like that they will become so tired. Now the time frame is fixed. The case should be filed immediately, and other fear is they don't want to identify themselves. So for that there is an e-filing procedure is introduced in this new criminal laws. What it means, they can file a FIR through mail itself. That is called e-FIR. But after that they have to go to the police station, they have to give it in writing, everything is there. But in an initial period, they can file through mail and zero FIR. This is also already included, but explicitly confirmed earlier the police station, the police officials may refuse. zero FIR. So this is not my jurisdiction, you can't file any complaint here, so you have to the proper jurisdictions, like that they can refuse the zero FIR. But now it is mandatory for them without concentrating on the jurisdiction. If anybody is going to the police station and filing, giving complaint, the crime which happened in any of the area. So without jurisdiction concentration, they have to accept the FIR, immediately they have to file it. This is the welcoming future on behalf of the society. That means complainant. But taking consideration of the police officers, it is very difficult for them to get it, because sometimes the police officers who is very lenient, they want to file the FIR that itself alone. In another station they won't go. So those who are very strict and following the procedure, wherever the police officer is convenient for the complainant, sometimes maybe the false complaint. So this is also, it is a negative perspective. So generally we are talking about the convenience of the complainant. So if you are taking the perspective of the police officials, they have, some officials have much burden, sometimes it may deviate it into the real sense. So these are the things for FIR related matters. If you are taking the consideration of or the perspective of women and children, so these new laws are very much concentrating on women and giving much privilege, much importance to the women and children. Already number of special laws are there in favoring the women and children. As per the constitutional provisions under Article 15 Class 3, the Parliament has the privilege to enact special legislation in favoring women and children because they are the weaker section of the society. So earlier